This is docket 25-6558 CK, Richard Robinson versus University of Michigan Credit Union. Counsel, your appearance for the record, and sir, you are Mr. Robinson?
Yes, I am. I'm Richard
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand up. Counsel, your appearance.
Good morning, Your Honor. Scott Church on behalf of the University of Michigan Credit Union.
Thank you very much. And sir, we have a couple of, you filed a couple of motions.
Yes.
Have you reviewed those, sir?
Well, just as a matter of housekeeping, there were a number of motions that Mr. Robinson filed. We were put in abeyance or held in abeyance until he could get to counsel. I think what's before the court today is Mr. Robinson's request to this court to extend the date for him to obtain counsel and to
Have a stay.
have a stay. Yeah. I think that's what's before the court.
But didn't I order? Did I order a judgment in this or no?
No, you
No,
don't.
there was no judgment.
Okay. There's just some back and forth here, but Mr. Valdori was out. All right. Okay. Thank you. Sir, at the podium, please. What would you like me to know in regard to your motion, and tell me what you've done to find counsel?
What I have done,
Sir, at the podium, please. Well, I guess you can stand there as long as you keep your voice loud. That microphone's not great. Perfect. Thank you. Okay.
I've worked, hello, Your Honor. I've worked earnestly trying to find an attorney. I've called at least 15 to 20 attorneys to try to work with me on this case. The issue is that I'm having is that they're reluctant to work with me on this case because documents have been filed and attorney and my former attorney has been dismissed. And so that is their reluctance. I have called the state bar. I'm working with them to try to find counsel to represent me in this area. And that is the reason why I've come to the court before the expiration of those 45 days that the court gave me to find an attorney. I'm here before the court before the expiration of that, seeking another 45 days. In addition to that, defendant has requested information from me. And that is the reason why I am asking for a stay in proceedings so I can get legal counsel. And I would also like to request within that 45 days to be able to file another brief within that 45 days because I need that to be able to adequately defend myself. I'm up against a wall here. And I'm working on this every day to try to make this happen within the time frame that the court has given me.
Response?
Thank you, Your Honor.
Sir, you can have a seat and then counsel will come up here. That's okay.
Thank you, Your Honor.
So here's where we are, folks. The credit union says, we had a deal, $4,000 and we're done. Mr. Robinson says, I never agreed to that. And Judge Aquilina, she's already sniffing out the real problem. Notice how she immediately zeroes in on the settlement amount? She's thinking, why is a $4,000 case in federal court? That's a huge red flag. And when a judge starts asking, how did this end up in front of me? That's lawyer speak for somebody is wasting my time.
Try to put this into some perspective if we can.
And can you just remind me when you're doing that? I thought there was an agreement already in this.
I was going to get to that.
And the agreement was through mediation, through counsel, that you pay, I think, $4,000, right?
The credit union would pay $4,000.
Or the credit union would pay,
That's
okay.
correct. Yeah. To back up just a bit, prior counsel was involved. We've got what I believe to be a settlement here. When we attempted to finalize that by exchange of money and documents, some turmoil between the plaintiff and his counsel. Counsel then withdrew after Mr. Robinson had indicated that he didn't agree to the scheduling conference order, which is now implicated by the motion because we've put on 45 days. I've sent some discovery to Mr. Robinson. He doesn't want to provide it. So it stands now, from the credit union's perspective, we have a settlement. Now we're backing up to allow Mr. Robinson to obtain another lawyer and give him more time after he's the one that filed the complaint.
And sir, could you remind me, the scheduling order, I remember hearing arguments from counsel. Was this was in mediation? Was it signed by the mediator and or all parties?
It wasn't in mediation. It hasn't gotten that far.
So what was it in?
It was an exchange of emails between myself and counsel.
Okay, that's what it was. I have a couple of these actually. People agree and then they have buyer's remorse. So, okay, I remember, I think counsel, it was probably somewhere in my file still, exchanged the email.
Correct.
Okay.
In which Mr. Robinson's counsel said, we have a deal for the $4,000 in releases.
So, explain to me how a case of $4,000 ends up in front of me.
Well, that's a very good question, especially in light of the fact that the underlying case was in front of Judge Jamo to start. Why that wasn't indicated by Mr. Robinson or why it wasn't assigned to Judge Jamo, since this case is basically a continuation of it. That's one. Two, the $4,000 is the amount we agreed to. His complaint was for damages in excess of $25,000.
Okay. And without going into all your negotiations, it's clear he wants counsel. He doesn't want to agree with the amount. What can you just tell me the fundamental basics of why $4,000 was reasonable?
Yeah, sure. I'm happy to. This settlement from the prior case culminates from a circumstance where Mr. Robinson guaranteed the debt of a former friend. That debt was then secured by his vehicle. There became some consternation between Mr. Robinson and the borrower from University of Michigan Credit Union. We agreed to release the lien on the vehicle to let him essentially out of the deal.
Do you recall how much the lien was on the vehicle?
My recollection is that the borrower, Ms. Egger, owed somewhere in the area of $1,800.
Okay.
And that the vehicle securing the debt was you have to forgive me, it was a Honda, is that correct?
The vehicle securing the debt was a Volkswagen.
What year was it, sir?
It was Volkswagen Jetta, 2010.
2010 Volkswagen Jetta. Through one circumstance or another, University of Michigan tried to release the lien. They sent the lien release to Ms. Egger instead of Mr. Robinson. Mr. Robinson then 3 years later brings this lawsuit to say that somehow we defrauded him into this settlement to release the lien on his vehicle. Since then, the credit union has provided Mr. Robinson with the lien release. So he's out of the underlying debt to the University of Michigan Credit Union, and now he wants damages. The damages we calculate to be at most what he had to pay out in attorney's fees to bring the case, because now he's got relief. In other words, the vehicle's free and clear.
And he has the vehicle?
He does. We never repossessed it.
Do you know did you ever figure out the blue book on the Jetta? My dad loved Jettas, by the way.
Yeah.
It's a very good car.
Apparently it's still running and after all these years, and I just have to smile because it just, my father's deceased now a couple of years, but we had a few Jettas in the family. I always drive American, but I have a few family members who like the Jetta, so I'm just smiling because it is a good car apparently.
It's a very
sure.
Yeah, so do you know what the blue book is?
The blue book is, as I understand it, is somewhere around $6,000.
Okay, thank you. You may have a seat.
Sure.
Could you please?
Thank you.
May I speak, Your Honor?
Yes, that's what I'm asking you to do. We take turns, so. They can tell you're not a criminal because you don't know your way around the courtroom, so that's a good thing. All right. So, that's okay. So, sir, I have some questions for you. Why do you think the $4,000 settlement was not good enough? Were your expenses covered? You have the vehicle.
No, but my expenses weren't covered. If I can go back just a little bit, Your Honor. when that agreement was signed some 3 years ago,
Mhm.
I signed the agreement. The opposing defendant signed the agreement, but the credit union never signed the agreement.
Well, they have emails. I saw emails last time that all the attorneys agreed.
No, this is the underlying case.
Oh, the underlying case. Okay.
I went to Mr. Chernich
Okay.
personally on 3 occasions within that 3-year period of time, and I asked him to sign the agreement. And I filed documentation with the court to show that.
Okay.
Over that 3-year period of time, Mr. Chernich did not sign the agreement.
Okay.
That is the reason why I brought the suit, because my car was still being held in possession of the credit union. They still had a lien on the car.
Okay.
And now to answer your question in regard to the $4,000, I believe that the damages that I have suffered, both mentally damages and other damages, far exceeds the $4,000.
Tell me about that. Let me just say, sir, are you afraid to drive? Are you afraid of attorneys? Are you housebound now? Are you losing sleep, in counseling, taking meds? I mean, what has this caused?
I have been taking medication. I am seeing a psychiatrist. I have been going to
all
counseling
related to this?
related to this issue. And this issue has been going on for 3 years. And this is an issue that I have tried to resolve 3 years ago by going to Mr. Chernich on 3 occasions. And on each occasion, he refused to sign the agreement. So what I am asking for now is the 45-day extension, a stay of proceedings, and the right to file an additional brief within that 45 days to explain my position. And I don't want to take up a lot of the, I'm sorry, I didn't mean to move that. I didn't want to take up a lot of the court's time. And within that 45 days, something has to happen, because I'm not going to come back and ask for additional time. Within that 45 days, it's either I find counsel, I drop the case, or I move forward in pro court.
Well,
But within that 45 days.
sir, I need to understand something. You have the $6,000 Blue Book Jetta. You like the car, it's yours free and clear. Prior to this case, there was an $1,800 lien, which has been forgiven. So now you have a car without a lien, free and clear ownership, correct?
Yes,
Okay, so you're under that you were not the borrower, or you were the borrower?
I was not the borrower.
Okay, so how did you get this vehicle?
Oh, I owned the vehicle.
So how did it have an $1,800 encumbrance on it?
What happened was, this was my former fiance.
Okay.
And she used the car as collateral for the loan.
And she had no right to do that?
And she had no right to do
Got
that.
it. Okay, so now that has been wiped away. So now you have a free and clear car.
Yes,
And on top of it, in order to cover your attorney fees, they've offered $4,000, which your attorney at that time agreed to.
but I instructed my attorney, I gave my attorney direct instructions in an email to not accept any offer without my written consent.
Well, that is your right, and that might be malpractice, but the problem is the other side relied on it.
The other side relied on it, but there's something else in addition to that, Your Honor, is that on the other side, in the release says there's a mutual release. My attorney accepted it, and it said there's a mutual release of claims. My attorney, my former attorney, has come back to me and said, because I asked him, what does a mutual release of claims mean? A mutual release of claims mean that all of the claims in the former lawsuit that defendant had against me would be dropped, and all of the claims in the current lawsuit that defendant has against me would be dropped. Neither one of those terms are in this settlement, this purported settlement agreement.
Okay, is that what you want? Do you want that?
No, I don't want that settlement agreement. I believe that settlement agreement is unenforceable, and I can prove that that settlement agreement is unenforceable.
How?
I can prove that based upon my attorney saying what should have been in that respective, that settlement agreement. I have it in an email, and those terms are not in the purported settlement
I
agreement.
got that, but sir, I think maybe I asked you a bad question. Let me rephrase my question.
Yes,
Let me
ma'am.
take some responsibility for that. What I'm asking you is, would this agreement be acceptable to you if it contains the mutual release of claims?
No, it would not, Your
And
Honor.
why is that?
Because I believe that the $4,000 that was settled against, the $4,000 that was entered into the settlement is not adequate to compensate me for my damages.
How much did you pay in attorney fees?
In attorney fees, I paid somewhere around, I believe it was about $1,700. But I've been going, as I said earlier, I have documentation of my psychiatrist that I have been seeing, the medication that I have been seeing, the medication that I have been taking, all because of this particular incident.
Wait, hold up. Did we just catch a contradiction? Mr. Robinson just said his damages are far exceeding $4,000, but then he admits the car's worth about $6,000 and he got it back. So let's do the math. Free car plus $4,000 cash minus $1,800 debt, he's actually coming out ahead. The judge notices this. She's trying to get him to see the bigger picture, but he's laser focused on one thing, the principle. And in law, the principle is the most expensive thing you can fight for. The question is it worth it?
I've been going through this for 3 years.
Okay, well, let me ask you a couple things. So basically, there's a $2,300 over the amount of your attorney fees, okay? So in regard to the $2,300, you're saying that's not enough to cover the damages, correct?
Yes, ma'am.
Okay, then are you saying that the damages are caused by the University of Michigan Credit Union, your attorney, or someone else?
My damages are caused by the University of Michigan Credit Union.
How?
My damages are caused by the University of Michigan Credit Union because for a period of 3 years, they did not take the lien off my car. And when I went to them to take the lien off my car on 3 occasions, when I went to Mr. Chernich and asked him to sign the agreement, he refused to do it.
Sign which agreement?
To sign the settlement agreement in the underlying case. Mr. Chernich refused to do that, and I submitted documentation to the court showing that he refused to do that on 3 occasions. This is the reason why I brought this case,
Okay.
and this is the case.
So let me just stop you there. I want to understand some of the working pieces here.
Yes,
Your former fiance,
yes.
sounds like it's good that she's a former fiance.
Oh, she's a very nice person.
I'm sure she is, but we all have formers and we're
Yes.
glad of it.
I've never
Good
said
people.
anything bad about her.
Okay,
She's a nice person.
Okay, but this nice person might need to be brought in this case because it appears that the starting point of this was your former fiance getting $1,800 against a vehicle she had no right to.
Yes.
So why is she not in this case? And why are you not claiming damages against her?
The reason why she is not in this, she was originally brought in this case. I instructed my former attorney not to dismiss her, and he dismissed her from the case.
Okay, I mean, if this is reopened, she's going to be brought back in, whether it's
Yes.
under me or the University of Michigan, because it sounds to me like she caused this. She was the pebble that turned into a rolling stone.
Well, she started it, but then the University of Michigan refused to sign the agreement. And when they refused to sign the underlying agreement, And again, I went to them on 3 occasions. I went to Mr. Chernich on 3 occasions, asking him to sign the agreement, and he refused each time. This is the reason why I am bringing this suit. This is the reason why I have these psychological and mental damages, which I have documentation of.
Mr. Chernich is not in this case, so you might have a claim against him in terms of, and I hate to always say this against,
But I asked him.
stop, sir. He
I'm
might
sorry.
have, I'm trying to explain to you, because this case is very fragmented. I'm not sure all of your claims fall under here. So you may have, you can certainly make a claim against him with the State Bar of Michigan if you believe he did not represent you properly. You can also file a malpractice suit against him, but that your relationship with your attorney, or the attorney for, I guess, University of Michigan, as he was representing the University of Michigan.
Mr. Chernich was representing the University of Michigan.
Okay, I'm sorry. So, but what about your attorney? You said your attorney.
Yeah, my attorney that I asked to withdraw, he was representing me, and it is the University of Michigan that caused me to have these damages.
Because they didn't agree with what you did? So, because I was getting my parties.
Because they did not sign the agreement.
So there's no claim that you would have against Mr. Chernich?
No.
Because they didn't represent you. I forgot there was the other attorney release, but.
Yes, no claim against Mr.
Right,
Chernich.
so he's representing his client. They don't have to agree to what you want. But there is this agreement. So your claim may be against your attorney who entered into this on behalf of your, I guess, against your wishes.
But that agreement is not a valid agreement. Even though it was done via email, that agreement did not have the terms in it that were supposed to be in it.
Okay, but I can fix that. I can put the mutual release of claims. Are you in agreement with that?
I'll do it right now, Judge.
Okay, and
But-
what other terms are not in there?
But that's not what I want, Your Honor. That
Okay,
agreement not only did not have the terms.
I'm not in the happiness business. I have to follow the law. And if there's an agreement, I'm going to make it better for you. I don't know if you can prove damages more than $2,300.
But I can prove that, Your Honor, and I need 45 days to be able to do that. That's all I'm asking the court to do, and I can do it within that time frame. That's all I'm asking the court to do is to give me 45 additional days so I can prove that to the court.
So you want this to come out of, because there's different laws in Michigan, and it can go by percentages. And so if the credit union is willing to give you $2,300, you might have to get the rest of the money from your former fiance,
But the
and maybe
amount,
your former attorney.
but the amount that the credit union has offered, that's an amount that I did not agree to. And I can prove that agreement was not valid, and that's why I'm asking the court to please give me 45 days.
I
So I
understand
can
that,
prove
sir.
that.
But then your former attorney may need to be brought in, and your girlfriend.
And that will be fine, sir. And I will do that.
But then I can release the University of Michigan. Your claim now then would become against those two.
But the University of Michigan, based on this agreement, it is not valid. That agreement is not enforceable.
It is enforceable based on the emails that I saw. There was agreement. Your attorney agreed, maybe should have talked to you. That's malpractice. That's a different problem. And you may have a claim against his insurance company and your fiance. It's just a moment. Sir, from there, you can answer this question.
Yes, ma'am.
What, in regard to the, I don't know, I'm going to phrase this horribly, so you fix it for me, okay?
Sure.
The credit union's responsibility because it's not just a responsibility to this stakeholder, but to all stakeholders who are in the credit union.
Correct.
And you have a lot of rules that you have to follow, and some of the rules that you all follow drive me insane as a consumer, okay?
Understandable.
So
I draft those.
Yes. So, were you, on the underlying case, were you able to do what Mr. Robinson wanted, or were there federal rules against it? Does that make sense to you?
I think so. Let me answer it this way, if I can. The crux of the settlement in the underlying lawsuit was for the credit union to release the lien. As I indicated to the court earlier, the credit union did that and sent the release of lien to Ms. Egger, which is Mr. Robinson's former acquaintance.
And I understand that,
And
but
then-
I want to take you one step backward. If
Sure.
you remember,
Yep.
he's claiming that this occurred over 3 years, should have been done immediately. Did the bank delay, or was it his former fiance that delayed? I mean, what caused this?
It was a mistake. The release of lien went to Ms. Egger instead of him. And then 3 years later, he brings this up. Now we sent him the release of lien. He's got it.
Okay. So why was it sent? I'll get to you, sir.
Yes, ma'am.
Why was it sent? I understand the mistake.
Yep.
Banks don't generally make that. But was it sent to her because she was the one who took this out with his, was it with his permission or without?
He alleges it was without.
Well, would the bank do that without? If we went into the bank records, I mean, I find it hard to believe that the bank, any bank, especially a credit union, with the extra layers of protection credit unions have over and above extra banks. I mean, they just have extra rules. I find it hard to believe that the University of Michigan Credit Union gave a third party a lien on his vehicle or any others without his permission, approval, whatever. How did that work?
We have
Do
a
you know?
very long history of his consent in allowing the lien.
And is that in writing?
Yes,
So he consented to her having this.
correct.
Sir, explain that one to me.
Okay,
How did they cause a problem if you consented?
okay. My ex, which was as part of the underlying case, asked me to sign a document. I signed the document. It was my fault. I didn't know what the document was. We made an agreement in the
Who's
underlying,
we?
myself, the credit union, and my ex.
Okay,
We all came together. I signed it on December the 23rd, 2022.
okay.
My ex signed it on December the 23rd, 2022. The agreement was sent to the credit union. The credit union did not sign the agreement. I went to the credit union on 3 occasions to ask the credit union to sign it. They would not sign it.
Was that the agreement to have, what was the agreement?
The agreement was for, once the agreement was signed, for the immediate release of the lien of my car.
Which they eventually did.
3 years later.
Okay.
And so again, I asked the court in regards to this purported settlement. I can prove that this settlement is not enforceable. If the court can't give me 45 days, then please give me 30 days. And I can prove that this agreement is unenforceable. And if you would allow me to have a stay in proceedings and also to submit a brief, I can do that within 30 days.
You can't have both a stay and submission of brief. The brief would have to come after the 30 days, but nonetheless.
After
also,
the 30 days.
sounds like this is a breach of contract case. Isn't the statute of limitations on contracts 2 years? Why are we here on that?
Statute of limitations, 6 years.
Okay, I'm thinking of something else. Okay. So,
And not only do we
why would,
accept,
I don't, sir, I don't know how you're, this case should not be before this court, first of all. Second, it's going to cost more to try this case than you're going to get. And I'll tell you why. I want you to think about this. You're going to have to get a psychiatrist, psychologist, doctors, all of those are expert witnesses to talk about how this impacted you so much that you have to be medicated, go to counseling, et cetera, et cetera. Then, on top of this, the liability will have to be divided between your lawyer, your ex-girlfriend or fiance, and the University of Michigan. And if it goes to jury trial, I don't have a crystal ball, but I've seen these kind of cases. Hingham County is very cheap on this, and they're going to look at a healthy guy who can represent himself, as you have, and be very organized, and say, we're not doing anything. Or they'll enforce the 4,000, and you're going to be out thousands of dollars on the expert fees. Plus, if we go to trial, there's a court rule that says if you lose, and you may very well, you have to pay the defendant. So are you willing to take all of that as a risk? Because there's a lot going on here that I don't see needs to happen in a court of law, at least this court.
I am willing to take that risk.
That would stress me out more than what you've already gone through. You understand this is going to elongate everything and cost you a lot more money.
I am willing to take that risk, Your Honor. I asked the court for 45 days.
Well, here's how I'm willing to resolve it. And I'll give you both a few minutes to tell me how I shouldn't do this. I am willing to enforce the $4,000 and add the mutual release of claims and whatever else you think should have been in this contract. It sounds to me like the University of Michigan Credit Union is agreeable to whatever the terms should have been that were not specifically in there. And then I'll give you the 45 days to bring in your attorney and your former fiance.
Your Honor, the motion that I appreciate very much of your input. The motion that I made today was to get an extension.
I understand. I'm not going to do that this way because I'll tell you why. I'll tell you why.
Yes, ma'am.
First of all, the credit union has eaten. They're paying you essentially $5,800. The $1,800 was forgiven because right?
Let me just clarify that. Ms. Egger agreed to make payments on the $1,800.
Okay, but it was.
She agreed to release the lien for that.
Okay, but it was, so you're getting that but from her.
Correct.
Okay, so that's done. I don't know. And the credit union is willing to pay you the $4,000, of which $2,300, it looks to me approximately, goes to your damages. And I'm not sure you can prove the rest. And it's going to, I think that the University of Michigan has done what they can do. And the other two parties need to be brought in.
And yeah, I appreciate your comment. I appreciate what you're saying.
Mm-hmm.
You asked me, am I willing to take that risk? I am willing to take that risk. And that is because I believe that I can prove that the $4,000 agreement is unenforceable. So I go back to asking the court.
I'm telling you it's enforceable. It's enforceable because your attorney signed it. And when he was here, I think there was an allegation and there was an exchange of documents in writing. And while you may not have agreed with your attorney, he agreed on your behalf, which is what the representation is, which is why I go back to it might be malpractice. But there was an agreement brought to writing.
There was an agreement brought to writing, but there is case law that proves that that agreement is incorrect. There's case law that proves that that agreement is unenforceable. And that case law indicates that when a agreement under, I believe it's MCR 2.50.
Okay.
When
it was based on mutual mistake and all these other things, but
no, it was that agreement was put together. In that agreement, it says that we're going to have The defendant offered a mutual release. My attorney offered a mutual release of claims. I have an email from my attorney that says what the mutual release of claims would mean. And I explained that to the court that the mutual release of claims would be a dismissal of all prior claims from the defendant and the claims here. That was not in the agreement that was subscribed. Case law indicates from the Michigan Appeals Court, case law indicates that when you have an agreement and those terms are not in the agreement, and you're supposed to put another agreement together where those terms will be in it, the underlying agreement is unenforceable. That is case law.
Counsel, was that an actual term that was agreed to that should have been put in writing? Do you recall that? I don't recall reading that in the email that went back and forth. I recall the $4,000.
I believe it was offered and accepted, $4,000 in mutual releases.
Okay.
But the terms,
which I'm happy to give.
Okay, so was this ever reduced to writing, and did you give him the $4,000?
No, because he fired his lawyer.
So that was in there. It was in the
Correct.
Okay.
the 4,000 is in the agreement, but the terms is not. And based on the Michigan Appeals Court case, those terms have to be in the agreement.
Do you have the email that says that, sir?
I'm sorry, I didn't bring that with me. I wasn't prepared for.
Do you have it? Do you have a phone that you can look it up on, or could you?
You know, Your Honor, if I could look at the file,
It's in the file.
I filed responses to.
Is it in your reply? Is it in this?
Yes, ma'am.
Okay, let me see. I remember looking at it last time. I just there's so many attachments. Oh wait, here. Exhibit 4.
I believe that's it, Your Honor.
Okay. And Counsel, I couldn't have you look at this, but I do have a very detailed letter that your attorney sent to you. I'll just read it. It says, Richard, on May 4th, 2026, I sent Scott Chernich an email providing him our counter proposal to settle the matter in exchange for UMCU paying you $12,000 per your instructions, and then I then had a call with, and it was wiped out, I think, because I don't have what that says. On Friday, May 8th, 2026, you and I had 2 telephone conversations. In the first call, we discussed that defendant was likely only to offer somewhere around $2,500. You told me you were looking to get $5,000 or something close to that. I then sent an email to UMCU's attorney stating that you would likely be willing to consider something around $5,000 to settle the case. He said that he would speak with his client and get back to me. On Monday, May 11th, 2026, Scott Chernich emailed me and said that his client was willing to offer $4,000 to settle the case. I immediately called you that day to convey the offer. I left you a message and you returned my call around 4:30 that afternoon. We had a long discussion about your case, the offer, and the expected costs for you to move forward. You unequivocally told me at the end of that conversation that you would accept the $4,000 offer from UMCU. I then conveyed your acceptance of that offer to Chernich. I then spoke with you later that evening and let you know that the case was settled, and I told you that I agreed to draft the settlement documents. You instructed me not to send the settlement documents to Chernich until you had an opportunity to review them. I told you that I would email you the draft. We set a call for May 27th, 2026 for you and I to discuss the draft of the settlement agreement. However, you indicated that you had just been released from the hospital and you would need a few more days to recover before addressing the settlement agreement draft. We agreed to touch base early this week. And I just want to note this letter was sent, or this email or letter, whatever it was, was sent to you Tuesday, June 2nd at 4:55 p.m.
Yeah, please look at the letter that is
And let me read. we set a call for May 27th, 2026 for you and I to discuss the draft of the settlement agreement. However, you indicated you'd just been released from the hospital and you would need a few more days to recover. We agreed to touch base early this week. You contacted my office June 1st and set an appointment for a call later this week. This call was just to go over the draft of the settlement agreement together before we sent it to Turnage. In fact, you are now claiming you never agreed to the settlement. The fact that you are now claiming you never agreed to the settlement is concerning. We had more than one conversation about it. You agreed to accept $4,000. I then confirmed the settlement with you that same day, and we discussed the drafting of the closing documents. If you want me to withdraw as your attorney in this case, that's fine, but please note that this does not and will not change the fact that a settlement was reached May 11th, 2026, when you agreed to accept the $4,000 offer. So how does this change?
This changed because on March the 2nd, I sent my attorney a letter, and that letter should be in that packet. On March the 2nd, which is way before his letter sometime sent to me in May, I said to him explicitly, I said, there's a lot of offers going back and forth. Do not accept any offer without my written consent. I also sent him a letter on March the 2nd and told him what the terms of that has to be.
Okay.
Those terms were not in that agreement. The amount I did not agree to, and I can prove that.
You can change your subsequent agreement with your attorney. It sounds like you had a very long agreement with the attorney on June 2nd, and you agreed to the $4,000.
I did not agree to $4,000, Your Honor. I did not agree to that amount.
All right. What else did you want in the agreement?
In that respective agreement, I wanted more than $4,000.
Or you wanted maybe $5,000?
No, Your Honor. This agreement started off, the offers going back and forth started off at about $18,000. And as you just indicated, Mr. Chernich offered $4,000 with a mutual release. My attorney came back with a counteroffer. His was a counteroffer. He did not accept Mr. Chernich's agreement, and Mr. Chernich did not subscribe to his counteroffer. So in addition to the terms not being in the agreement, and you asked specifically what terms, those terms were to be that the defendant, University of Michigan Credit Union, were going to release all of their claims against me.
Mm-hmm.
I was going to release all their claims against them.
Yes, and what else?
Defendant Egger was going to release all of her claims against me, and I was going to release my claims against her. None of that is in there in this proposed settlement agreement, and nor is the amount correct, because I did not agree to that.
Well, she's not even in this case, right? Is she or is she not in this case? Was she ever?
She was in the case.
Well,
yes, she was.
When did she get out?
She got out of this case. You signed the order to get her out. I believe that was sometime in April. You signed the order.
Okay, here's my ruling. Counsel, you're going to draft a proposed order under the 7-day. Sir, that means that if he does not follow what I say, then you can file an objection, and then you can propose another order to me, and then we'll have a hearing and I'll decide which one I'm going to sign. But here's the order of the court. It appears very clear to me that there was an agreement. It does appear very clear to me that Ms. Egger was out of this case prior to this June or May agreement. She was out in April.
Mm-hmm.
I only have part of the file, but I remember signing that. That's why I asked when she was out. But nonetheless, I don't know that she needs to be in this. If the university wants to add that she's released, that's fine, but that would really take her to be on notice and be part of this case, and she was out long ago. So I think that signifies, at least to me, that the claims have been resolved, and if he wants to file another claim against her, I suppose he can do that. But this clearly needs to have the $4,000 that will be paid to him within 7 days of the court signing the order.
And that's a wrap. Judge Aquilina just enforced the settlement. Mr. Robinson gets $4,000, the credit union gets a release, and the case is closed. But here's the kicker. The judge basically told him if you have a problem, go sue your own attorney. That's a huge blow. The legal term for this is buyer's remorse through ineffective counsel. But let's be real. Mr. Robinson's fight isn't over. It just moved to a new courtroom. The question now is, will he take the money and walk away, or is this just Act 1? Drop your thoughts in the comments. What would you do in his shoes?
The $4,000 will be paid. There'll be in that order a mutual release of all claims between the two parties that are left in this case, and that is Mr. Robinson and the University of Michigan Credit Union. There'll be no attorney fees, no interest, no nothing. He gets his Volkswagen Jetta free and clear, which has already happened. That doesn't necessarily need to be in the order. If you want to put it in there, it's already been done, so I think that's moot. And that would close this case. If you want to file another one against your attorney and your former fiance, you're within the 6 years, so you can certainly do that. But I think there was an agreement, it's outlined here, and suddenly you were unhappy with it. So, and there's no reason for me to keep this case open, sir. I'm terribly sorry, but I don't. I think this was still an agreement.
May I speak, Your Honor?
You may.
But, Your Honor, you can't make an agreement when an agreement was not there.
Looks to me, based on the writing of your attorney, that there was an agreement. And what happened, sir, is in March or sometime during your relationship with your attorney, you said, I want this, that, and the other thing. And he said, okay, I'm going to try to get it for you. And then he did. Now, during the negotiations, and you got the $4,000, it wasn't put in there. You can change your mind. I have nothing in there except before, long months before this agreement goes in writing. They're willing to do that. So there's nothing else really to litigate. I know you say you have more damages, but it's very clear that you went down from whatever it was, the $25,000 that brought you here, down, you wanted more, you wanted $12,500. They said no. You said, okay, $5,000. It came at $4,000. There was some back and forth negotiation. I'm not going to get involved in that. I'm going to enforce a $4,000 settlement. You'll prepare the order, sir?
I will, Your Honor. Thanks.
So, sir, your next step would be to Court of Appeals or to file a case against the other two people.
In that order, are you saying then that the claims in the underlying case are released as well?
Wasn't that your understanding?
Yes, my understanding.
Yes. So it's all released. You got what you want. He's agreed to it. Is that right, sir?
Yes, Your Honor. Yes.
So all claims are resolved. These are released. You release them, they release you. Now, if you want to go against the other two parties, that's fine.
I'm perplexed.
Well, that's why we have a Court of Appeals. I don't always get it right, sir, but from what I see in the history here, I think that there may be claims against the other two parties who are not parties here, but the credit union has kept up their bargain, and they're even willing to put in the other piece that apparently you discussed and wasn't in their discussions, however that happened.
But I didn't agree to the $4,000 amount.
That's between you and your attorney, because what happened was credit union relied to their detriment on what your attorney said. So that would be an issue for the state bar or another lawsuit, not against this party who relied in good faith. So that's the problem, sir, is you have a couple, there's a spider web here. The credit union negotiated in good faith. And I don't know what happened between you and your attorney. That's for another day in court. And I think legally this makes sense. I understand your case law. And if it was just the agreement between you, if you had personally made it with defendant, and it wasn't in there and you agreed only if it was in there with them personally, that would change my mind, but you used counsel, relied on counsel. I don't know what happened there, but you may have a claim against counsel, but you don't have a claim against them. They relied on this agreement that counsel conveyed, and there was sufficient negotiation going back and forth. And although you indicated back in, March to your attorney what you would and wouldn't do, this was an agreement that continued to morph until it was finally agreed to, $4,000, and you got your power of free and clear. I think it's a right and just settlement against the credit union based on what I know, what everybody's pled in the, not just this file, but there's an underlying file that I have here. And again, you may have a claim against the other two parties, but the credit union's out. You'll prepare an order?
I will, Your Honor, thank you.
Thank you. Good luck to you, sir.
Thank you, Your Honor.